Welcome to the Atheist of Florida YouTube channel. We are pleased to offer some of the most significant speakers and profound issues of our times. If you like today's video, please hit the like button. If you have already subscribed, thank you. If not, you know what to do.
So first, I'm going to go over a little bit of information about the American Atheist Legal and Policy Center and what it is we do, and then get into the issues of this case. I'll start by running through some recent cases from the last two Supreme Court terms because they raise questions that cases coming up this year will answer, and questions that a number of cases that we are participating in hope to answer in a way that is favorable to toward religious equality. Then I'll talk about the shadow docket and what exactly that is. It's gotten a fair amount of coverage lately in the news because of particularly the abortion case out of Texas in the last few weeks. But I'll get into a little more detail there so that I can demystify it a little bit. Then I'll talk about some upcoming cases from the Supreme Court year that starts next month, and finish with the current state of the Establishment Clause and how we need to be approaching the enforcement of the rights of atheists, non-believers, however you want to, whatever label you want to use. So that is the plan for this. And by the way, if anyone has a question, you're welcome to ask. I'm not sure how we're facilitating that in this particular call. If it's easier, we could just leave them till the end, but I am happy to take them during. Will people be raising their hands?
Yes, people are asked to raise their hands. For those who don't know, you go down to the reactions and it'll have a click on that, and it'll have a raise my hand function in there. And we'll recognize you, and you can unmute when we recognize you. Please stay muted until then.
Great. So as Jim said, I am the litigation counsel for American Atheists. Our American Atheist Legal and Policy Center is based in DC, though American Atheists is itself based in New Jersey. And we work to protect religious equality and the rights of atheists through a number of different means. As Jim said, my field is litigation, but also trying to work constructively and build relationships with governmental bodies so that we can reach solutions to problems without having to resort to litigation, because litigation is an incredibly time-consuming, stressful, expensive process, and so we always try wherever possible to avoid that. It is the last resort, though we are willing to use it if we need to, as we'll get to in a bit. I also file amicus briefs with the Supreme Court and various appellate courts. Amicus briefs are when you file a brief in a case that you're not actually a part of, but you're just advising the court on an issue that the parties themselves might not raise or consider. For instance, next month I'll be filing an amicus brief in the Carson v. Makin case, which is a case about school funding out of Maine. So that's another aspect of what we do. My boss, our Vice President of Law and Policy, Allison Gill, is essentially our lobbyist. She engages in advocacy and at both the state and federal level to try and encourage lawmakers to pass bills that protect the separation of church and state and oppose bills and policies that damage that separation. So we try and take a two-pronged approach, and then we have a team of law clerks that assist us in that. So that's a very brief overview of what we do. I think the state of the Supreme Court can be summed up with these three words: credulity, inconsistency, and favoritism. That's how the last, unfortunately, that's how things have been trending for the last decade or so on the court, and increasingly so in the last couple of years. I pulled a quote here. It's from Justice William O. Douglas, dating back to 1952, that shows kind of how longstanding this problem is, though it's really become acute of late. In a case about taxation, I believe, the Zorach v. Clausen, the court said, "We are a religious people whose institutions presuppose a supreme being." Now, when I read that in the case, I raised my eyebrows, of course, because it doesn't seem to me, I mean, sure, we are by and large a religious people. Americans tend to be religious, no disagreement there. I don't know what it means to say that our institutions presuppose a supreme being. It seems to me that our institutions don't presuppose a supreme being. We wouldn't need our institutions if there were a supreme being, is my feeling of it. But he made this statement, and he made it without any reasoning to support it, without citing to anything at all to support this claim. Just a bald statement of his views of American society and the law in our country. And the recent court has really taken this to heart, it seems to me, this attitude of, just making statements and not really supporting them in any real way. So yeah, I feel like those three words really sum up the state of things right now when it comes to the rights of religious minorities. And I'll get into each in a little bit. Hang on, I noticed there's a couple of things in the chat. So I wanted to start our discussion with a couple of cases from the 2019 to 2020 Supreme Court session that are of particular importance here. First is Bostock v. Clayton, which is actually a case which is actually a combined case. Three different Supreme Court cases were lumped together and decided all in one. And if you're aware of this case or these cases, you're aware of them because this is when the court said that discrimination in employment on the basis of sex includes discrimination on the basis of gender identity and sexual orientation, that you can't discriminate on those two bases without discriminating on the basis of sex. It's just, they are inextricably linked together. But what the court expressly left open is the question of whether a religious employer would be entitled to discriminate on the basis of gender identity or sexual orientation based on their religious beliefs. They expressly said they are not answering that question, and that therefore remains open. And that is troubling because one's religious beliefs should not trump the rights of others. One of the main principles of First Amendment law, when it comes to religion, is that an accommodation of one person's religion can't unduly or really burden in any way some third party. You can't place the burden of the accommodation onto another. And if accommodating someone's religious beliefs means allowing them to hire or not hire or fire someone based on their gender identity or sexual orientation, that is an impermissible expansion of the Free Exercise Clause, and something that we need to pay very close attention to. Next up is a case from also from 2019 called Espinoza v. Montana Department of Revenue. This case, like the one I mentioned a little bit ago, Carson v. Makin, is about school funding. And the court, there was a lot of weird stuff in the history of this case, but essentially the court said that Montana's program for providing funding to private schools, but excluding religious private schools from that funding, was a violation of their free exercise rights. And it didn't matter that the state had ended the program altogether. By the time it got to the Supreme Court, the state wasn't funding private schools, whether they're religious or not. but the Supreme Court told the states, you have to essentially reinstate that program, and it has to be available to all private schools. That is obviously very troubling, because the Supreme Court should not be directing states to reinstitute programs and tell them the scope that those programs have to take after the state has made a decision not to provide that program, and do so in a way that is non-discriminatory. The key of that case, and what we need to keep in mind in terms of what it means for future cases, is the court drew a line, and I apologize. I'm probably making this a little too legalistic. I'll try and do my best to avoid that. But when it comes to government programs, and whether a religious entity or a religious person can participate in that program or can be excluded from that program, depends on whether the money that the government is providing, or the benefit that it is providing, whether the person seeking the money or to participate in the program is being excluded because of their religious identity. They're Catholic, therefore they can't participate. They are religious, therefore they can't participate. Versus they plan to put the benefits of this program to religious use. So this government program is going to be used to help support a program that's proselytizing to children, things like that. The court has drawn a line some time ago between funding, between programs that avoid providing funding to religious entities based on the religious identity of the recipient versus the religious use. And here, the court kind of blurred that line. And there's another case coming up this coming year, like I said, Carson v. Makin, that could blur that even more. This all arises from a case called Trinity Lutheran v. Comer that came from Missouri. A church and school, Trinity Lutheran Church and School, is a church and school in Columbia, Missouri. Actually, which incidentally is a town I used to live in. I've been to this church as a support technician for election polling technology, and so the case struck a little close to home for me. But in that case, the church was seeking to participate in a state program that provided recycled bits of rubber tire, to institutions that wanted to use it to resurface playgrounds. It's a very good program, disposes of a lot of waste and keeps kids safe. That's great. But the program had a carve out that said it's that because of the state's version of the federal establishment clause, the program didn't allow religious institutions to benefit from it. And the school, Trinity Lutheran, argued that they should be entitled to it, that the playground was open to the public, it's not being used for religious purposes, and that excluding them violated their free exercise because they were being excluded, specifically because they were a church and school. And they won. The Supreme Court said that they were entitled to participate in that program. Now, the fact of the matter is that playground is fenced in and sometimes locked and not so available to the public as they would have the Supreme Court believe. I've been there, I know firsthand, or at least it was when I was there. Perhaps they've taken the fence down. Who knows? Which also highlights another problem, which is one of the three words I mentioned at the beginning was credulity, that the courts will bend over backwards to give credence to the religious beliefs of someone claiming a free exercise claim. The courts are precluded by the Constitution from examining the reasonableness of someone's religious beliefs. The courts can look at whether they sincerely believe what they believe, but they can't say, no, your belief is wrong, and therefore we find X. To a certain extent, that makes sense, but there needs to this isn't the discussion for it, but I argue that there should be some bounds to that that the court hasn't really established, which is troubling, but a discussion for another day. Anyway, that's a rather long and rambling discussion of Espinoza v. Montana Department of Revenue and the question that leaves open, which is this question of whether you can exclude somebody for putting a government program to a religious use and what exactly that means. What does it mean to put something to religious use versus be excluded for the fact that one is religious? So we'll come back to that. Another one I wanted to highlight was Our Lady of Guadalupe School v. Morrissey-Berru. There is a principle called the ministerial exception that lies at the intersection of Title VII of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, religion, nationality. There's a carve-out in the statute for Title VII that says essentially a religious organization can discriminate in employment based on and favor their co-religionists. A Catholic school can give a preference to Catholic teachers. A church can give preference to a Catholic janitor or a Catholic organist or something like that. And again, that carve-out makes a fair bit of sense. The government shouldn't be telling religious entities, nor should it be telling atheist entities that they have to hire people who don't hold their same religious views. Because, like I said, that applies to everyone across the board, be they Catholic, Muslim, Christian, Mormon, Jewish, atheist, what have you. So that principle within Title VII also intersects with the Free Exercise Clause, which requires the government to refrain from telling any religious entity who it must include. The government can't say, you must admit this person as a member of your congregation, you must admit this person as a leader of your congregation. That is forbidden by the Constitution. So, in a case a while back, Hosanna Tabor v. Equal, oh man, sorry, I'm fumbling my words. Hosanna Tabor v. Equal Employment Opportunity Commission. The court said that when it comes to a religious entity hiring and firing its ministers, the courts are essentially precluded from examining a claim of employment discrimination. Beyond just the question of, did they discriminate against you because you are not a member of their religion? In the Hosanna Tabor case, a teacher was fired from a school essentially because she had narcolepsy and she missed a lot of work. Now, the Americans with Disabilities Act prohibits that kind of discrimination, and it doesn't have any carve out for religion. And so their action of firing her did violate her rights under the Americans with Disabilities Act. But the court said that because of the nature of her position, she was a called teacher and had some religious training, and she led the students in prayer at the beginning of class, those kinds of things, that she constituted a minister. And because she was a minister, the courts could not hear her claim, essentially. That case had to be dismissed because when it comes to ministers, religious entities can discriminate on any basis. And this was expanded a little bit in Our Lady Guadalupe School v. Morrissey-Berru, because the court has refused to put down any clear definition of what constitutes a minister. It's a very vague concept. Plenty of religions obviously don't have ministers that use that term, but do obviously have leaders, clergy, that kind of thing. And the court has refused to lay down any sort of hard and fast rule. Nevertheless, they have listed a bunch of factors that they will weigh in when determining whether or not someone is a minister, including, for instance, whether they've had religious training, whether they hold themselves out as religiously qualified in some way. And since she was a called teacher, she met that qualification. This case added another, sort of reclarified some of the factors that the court had introduced previously. Our Lady of Guadalupe School, they added, I don't want to say added. They said that employees that perform vital religious duties will generally be considered ministers, or at least that these teachers in these cases did. Again, this is a combined case. So the question is now, what constitutes vital religious duties? Because, for instance, let's say you're a doctor working at a hospital, and you've been working at that hospital for 20 years, and suddenly it's being bought by a Baptist medical system. The religious takeover of our healthcare system is a troubling trend, and this specific scenario has happened. Your employer suddenly is taken over by a religious organization, and they start instituting policies of, whether it's bringing patients to chapel for religious worship, or praying with patients, or not counseling patients on particular healthcare options that might be available. Suddenly you're very restricted as a doctor or a nurse in what you can do. And it seems to me that religious entities will inevitably start claiming that after they fire a nurse or a doctor for not meeting their religious requirements, that they'll claim that the nurse or the doctor is a minister, and therefore they were entitled to fire them or refuse to hire them on whatever basis they want, and the courts have nothing to say about it. So that's another sort of open question that we're keeping an eye on in the court in future cases. We recently just filed an amicus brief in a Second Circuit case involving a New York statute that's colloquially called the Boss Bill. It was a change to New York labor law that prohibited any employer from discriminating against an employee based on that employee or the employee's dependents' reproductive healthcare decisions. You can't discriminate, demote, fire, refuse to hire someone based on whether they had an abortion, didn't have an abortion, are on birth control, aren't on birth control, picked an IUD as birth control over the pill, those kinds of things. And a crisis pregnancy center, which is to say not a women's health clinic, sued and said, well, we're a religious entity. We have a position that says, abortion bad, and therefore we should be allowed to fire people who don't abide by our, religious requirements. If they have had an abortion, then that means we should be able to fire them because, it's putting a bad faith. It seems hypocritical. They aren't able to authentically present our view in their job. Never mind that whether or not someone has an abortion is a deeply private medical decision that your employer should never know of. And because it prohibits discrimination based on the employee's dependents, you're essentially putting coercive you're allowing, if the courts give this crisis pregnancy center an exemption from this law, they are essentially giving that entity the right to coerce the employee's children in what they do with in terms of their own healthcare. And that is deeply troubling. Like I said, the court cannot accommodate a religious belief on one side by putting the burden of it on someone else. And I can't think of a more burdensome accommodation than to say, you, 23-year-old college student, have to abide by your parents' employer's religious requirements, or they are permitted to fire your mother or father, who, by the way, might be paying for your college, might be paying for your room and board. And it's not just college students, it's, it's anyone of childbearing age. So that's all kind of bound up in the ministerial exception and whether or not religious entities' beliefs trump anti-discrimination law. And it really is a developing question, and it's not trending in a favorable way. Though there was a case just a week or so ago, and forgive me, I didn't write down the name, where the court did determine that a teacher at a school was not a minister because potentially they taught, I think, music or theater, and it didn't have any religious component to it. And they determined that the trial court determined that was not a minister, and that the court could hear the employee's claim for illegal discrimination. We'll see whether the appellate courts uphold that or overturn it. I'm not optimistic. Nevertheless, maybe we'll see some bounds put on this in the near future. We're keeping an eye on it. That kind of wraps up 2019, if I'm remembering my dates right. Yes. So before I get into the cases from 2020, are there any questions? I don't want to wait too long before addressing any.
Yeah, there is a question in the chat from Michael. I don't know if you want to read it. It's kind of long, or do you want me to read it to you, or get Michael to ask you?
I'll read it. In McGowan v. Maryland and Marsh v. Chambers, the courts used to use the force of tradition to support laws that were obviously not in line with the Establishment Clause. Quite true. I'm actually going to be getting to that in a bit. The current line of thinking seems to be that you can use the argument that if a practice has been traditionally practiced, it is somehow okay to continue. For example, religious invocations before government meetings, invoking religious figures during legal cases, and swearing on a Bible to verify truthfulness. This is obviously an attempt to circumvent the Establishment Clause by saying that tradition trumps law, since atheists and the non-religious don't have that long tradition in government, because atheists have not been, scroll too fast, because atheists have not been usually viewed very favorably by the courts. How do we address this loophole, especially with today's very non-friendly Supreme Court? That is all pretty accurate. The court has increasingly said if something is a long-standing government practice, there is a presumption that it is constitutional. There are some big flaws with that argument. Most recently, I don't know if, I imagine a fair number of you are familiar with the Bladensburg Cross case from 2018. I actually thought about including it here, but if I include 2018, then I'm including a number of other cases, and I didn't want to cram too much into this talk. But in that case, the court allowed a 40-foot tall Latin cross to stand on government property and be maintained by the government because for a couple of reasons. First, because it had stood there since, I think, 1920. I think, but don't quote me on that because I haven't looked at the case in several months. And the cross, in addition to its religious symbolism, symbolizes the deaths of veterans from World War I. Never mind that it symbolizes only the deaths of the Christian veterans from World War I, and that something having one ancillary secular meaning does not completely eliminate the obvious religious meanings of these symbols. Nonetheless, that's what the court said. And what that means, and what I'll get to a little bit more later, is that we have to really be on the ball when it comes to challenging these the violations that we see. We have to object quickly and vocally when we see potential violations going on, because sitting by, the longer something goes without being challenged, and the more we kind of sit on our hands and say, well, I don't want to make a problem, I don't want to, rile people up, then the more acceptable it will become. And the court has not given any clear line. I don't think they could establish any rational, clear line as to when something is long-standing enough to be essentially immune to constitutional challenge. But I'm not eager to find out where that line is, because I don't think, they might say no one challenged it within the first year, so it's fine. It's another way for the justices to inject their own subjective ideas of what constitutes acceptable into the legal sphere, and I'm always troubled by that. I think there should always be objective factors to consider, and with clear lines built in. And this is the opposite of all of that, and so very troubling. So, Michael, thank you for the question. Was it Michael? Yes. With that, let me move on to the 2020 to 2021 term. Oops. So there were two cases of particular importance to us in 2021. And of course, I've skipped a slide, and there we go. The first one is a case called Tanzin v. Tanvir. And the facts of the case are rather horrific. A number of FBI agents approached a number of Muslim men and asked them to essentially spy on and inform on their congregations, presumably to root out terrorism and that kind of thing. The men refused to do that, and when they refused to do that, they were placed on the no-fly list. As a result, one guy lost his job because he was a long-haul trucker, and so he would, drive from New York to LA and then take a flight back once his drive was done, because there's not going to be another truck waiting for him to drive back. That's just not how that industry works. So if he's on the no-fly list, he can't do that anymore. And he ended up losing his job. One man was unable to fly back to Pakistan to visit his dying mother. Some really bad consequences flowed from these FBI agents' actions in that case. And that was frankly terrible. The problem is they sued a number of government officials, those individual FBI agents, for financial damages that the government officials would have been individually liable for. And there's a law called the Federal Tort Claims Act that allows you to sue government officials when they have committed a tort, which is a type of violation of someone's legal rights. When the government has committed a tort against you and caused you some sort of financially compensable loss. And that's good. People should be, I live down the street from the Pentagon. So if, let's say, some groundskeeper working at the Pentagon runs into me with his truck and totals my car and causes me medical injury, I should be able to bring a suit against that individual and the government to recoup my losses. That makes sense. Absolutely nothing wrong with that. The problem is that the law specifically exempts law enforcement activity. So if the cops break down your door, and it turns out, oops, or well, let's say the FBI. The FBI breaks down your door to make it a federal, to make it a federal official. And it turns out that the warrant was wrong. They meant to be breaking down somebody a block away or your next door neighbor, but they got your place by mistake. Nevertheless, they've damaged your home. They've maybe damaged personal property in the course of conducting a search or something like that. That's all law enforcement activity, and you can't sue them for financial compensation for your losses there. So the financial losses of these particular individuals were caused by the FBI conducting law enforcement activity. I think ill-advised law enforcement activity, but law enforcement activity nonetheless. And so the law precludes them from getting a recovery. They argued that under RFRA, the Religious Freedom Restoration Act, they should be entitled to receive money from the government officials because their actions burdened their religious exercise. And the court agreed. The court said that, yes, you can sue individual government officials under the Religious Freedom Restoration Act for financial damages. Now, that sounds on the surface maybe like a decent workaround for the fact that otherwise they would have had no recourse. The problem is that RFRA might or might not be a remedy that's available to everybody. If the men who were approached by the FBI agents in that case were ex-Muslims instead of practicing Muslims, and the FBI asked them to go and attend and spy on their former congregations, it's very unclear, and I think unlikely, that they would be allowed to recover their damages under RFRA, making this essentially a remedy that's only available to religious believers. Something that's highly problematic, I would argue a violation of the Establishment Clause. And more than that, by allowing lawsuits against individual government officials to recover money from them, you're incentivizing run-of-the-mill government officials who may not know on the fly whether or not a religious exemption to whatever law they're trying to apply or enforce, whether a religious exemption is acceptable or permissible. You're essentially hanging the threat of losing their house, losing their life savings over their heads unless they grant that exception, because there's very little consequence if they grant an exception. Whereas if they don't grant the exception and the exemption and somebody sues them over it, they could find themselves in dire financial straits. We pointed all of that out to the court in an amicus brief. Nonetheless, the court went the other way. So a very troubling case. The open question being, does the Religious Freedom Restoration Act apply to the non-religious? I argue that it must. We'll see whether the courts go along. Then the last of the, not quite the last of the non-shadow docket cases I'll cover today was Fulton v. City of Philadelphia. Fulton v. City of Philadelphia involved Catholic Social Services and the contract that Catholic Social Services had with the City of Philadelphia to provide foster placement services. The city learned that Catholic Social Services, CSS, was refusing to place children with, or refusing to certify LGBTQ couples as sound foster placements, and would refer them to other agencies. The city had a non-discrimination clause in their contract that said you can't discriminate against people on the basis of sexual orientation or gender identity. And CSS went to the courts and won, and got the courts to essentially direct the city to continue contracting with them for those services, despite the fact that they would discriminate against certain couples. And all of that was permissible because the court the court found that the contract had a built-in exemption. Essentially, the Commissioner of Human Services for the city could, under the right circumstances, had the authority to waive the non-discrimination requirement. She had never done so, but nevertheless, the provision was there in the contract. And because the provision was there in the contract, and the city therefore could continue to contract with people even if they discriminated against or discriminated on what would have been a prohibited basis. That because of that, the contracts were not generally applicable. Under a case that actually Justice Scalia wrote back in 1990, Employment Division v. Smith. Justice Scalia said, if a law is of general applicability, if it applies to everyone, and it applies neutrally toward religion, like if it doesn't single out Santeria or Jews or Muslims for any disfavorable or favorable treatment, then the fact that that law might incidentally burden someone's religious exercise is not a constitutional violation, unless it's completely unreasonable. If, however, a law is not generally applicable, if it doesn't apply to everybody, if it only applies to like a subset of people, or if it's not religiously neutral, then it's subjected to something called strict scrutiny. And strict scrutiny is a standard that the courts impose that is incredibly hard to meet. It's essentially limited to, it's only applied to laws, well, not only, it's generally restricted to laws that discriminate on against people based on certain suspect classifications. Again, race, religion, national origin, gender, those kinds of things. And what it says is that the government, if in this context, if a law is not general or not neutral, then the government has to show that the law is narrowly tailored to achieve a compelling government interest. And essentially, the government has to show that it was attempting to address a very serious concern of the government, and that this was the least restrictive means of doing that. And that is a very difficult test to meet. And so, because this contract was not generally applicable, because it had this one potential option for an exemption, should the Commissioner of Human Resources, Commissioner of Human Services, decide, should the Commissioner of Human Services decide to allow an exemption, she could. That therefore, she could not, she essentially must grant an exemption to Catholic social services. I noticed there are a couple of other messages in the questions here. Judy, I'm not sure if this is a question. There's a proposed statute for the Florida legislature concerning harassing the police being prohibited. It has a loose definition of what constitutes harassment.
I realize that's not directly related to religious freedom, and Brent asked a question just before mine that is probably more appropriate for you to address.
Okay, let me find it. I wonder if the same arguments used to remove Confederate statues could be used on religious icons. Yes, I mean, those aren't generally legal arguments. Those are sort of grassroots arguments that are very effective in this context, or in the context of Confederate statues. I think how to word this? If discrimination and on the basis of religion were treated the same way discrimination on the basis of race, or if society viewed religious discrimination in the same way it views racial discrimination, I think those arguments would work. The problem is that far, far more people are willing to allow government religious messages than they are willing to allow government messages that favor or disfavor a particular race. So while I think the same arguments apply, I don't think that people in general will be as receptive to them, unfortunately. And, you know, maybe that's one avenue that worth exploring to change that attitude. I don't know. I'm just a lawyer. I'm not a sociologist or anything like that. Let's see.
Michael has another one down there concerning healthcare policies in his place of employment.
Sure. I work with the Illinois Department of Human Services, and foster placement services is the tip of the iceberg when it comes to violations. For instance, in Illinois, Medicaid will cover things such as going to see a Christian Scientist as your medical provider, as well as things such as seeing chiropractors and, I believe, acupuncturists. Illinois' argument is that not allowing clients the ability to see these very non-medical practitioners is abrogating a client's right to medical care. Never mind that none of these people actually give true medical care. Agreed. I did contact FFRF about this, and they said that it is just so common that they simply do not have the resources to challenge all the state laws that do these things. Given the pervasiveness of such state organization practices, what would the best tactic for individuals to start the ball rolling on bringing these violations to light in a way that will get to the attention of people who can address these problems? I would take a page out of the Merseyside Skeptics Society over in the UK. They have been, I mean, obviously the laws in the UK are much different, but they have done an incredible job of bringing attention to the wasteful spending and rampant violations of various medical regulations and things like that by chiropractors, acupuncturists, homeopathy practitioners, that kind of thing. So unfortunately, I'm not sure that you could bring any sort of legal claim there because, I was going to discuss this in a little bit, and I've already touched on it some briefly, but the courts are not going to tell somebody, are not going to tell someone your belief in acupuncture is invalid because the First Amendment says they can't, at least under the current interpretation. Now, I would argue that if someone's beliefs are demonstrably wrong, then there should be some ability of the courts to set them aside. That even that principle has its limits, but the courts haven't gotten there yet, and I think it's going to be a generation or two before they do really address that question and have any sensible answer to it.
So, given what you just said, does that mean if I were a member of the Satanist church and I wanted an abortion and I was on Medicaid, could I sue to get my abortion paid for because it's a ritual in my church?
let's
You don't
see.
have to answer it. I'm just.
I mean, that is a complicated question. And they couldn't say your belief that it is a ritual is invalid, but what they would probably say, depending on what this kind of comes back to that use versus identity question, that if it is a religious worship practice, then it shouldn't be receiving federal funding. And actually raises one of the kind of tactics that we have to think about in bringing cases is bringing cases where even if you lose, you kind of win. So, for instance, if someone were to take that case, if someone were to bring that case to court and say, "I'm a Satanist, abortion is an integral part of my religion," and the court were to say, "No, it doesn't apply because this is religious exercise and the government won't fund it," then that becomes, yes, you lose that case, but later down the road, that's precedent that we could point to limit federal funding of other religious exercise. And so it is kind of an indirect win. It's not a great win because it doesn't affect the availability of abortion to the general public and women who need it, but could be useful in other ways down the road. Any more in-depth analysis, and I'll have to do some research and write a memo or something.
No, that's okay. I was just speculating, but I do have. I don't want to interrupt your train of thought with your thing, but I do want to throw one thing out there. Almost all the hospitals in our area are controlled by religious groups.
Yeah.
And restrict what access you have to certain kinds of medical procedures. And is there any chance of that being challenged in any way? Because they're getting lots of federal and state funds.
Sure. There may be avenues. It's something that we are actively looking into. But I don't want to get into it.
Yeah, that's fine.
I would be more than happy to have a long conversation with you about the state of things down in Florida on this particular point. It's just, I notice we're an hour in already.
Sorry.
It's okay. How long do we have? I don't remember how long.
It's as long as you want. It's normally an hour and a half, but we got started late, so we're going to probably run over, which is okay.
Sure. And my Sunday evenings are usually free, so.
So are ours, except for this.
So Fulton v. City of Philadelphia, what was I? Where was I? It's not generally applicable, and so the government had to show that it was the least restrictive means of achieving a compelling government interest, and essentially, the court said that the government had not met that burden. This also touches on something called the most favored nation theory, and it's something that I'll get to again in a moment. But briefly, what this means is that if the law exempts any activity, any secular activity, or exempts any activity for secular reasons from a particular law, regulation, what have you, religion must be treated as well as the most favorably regarded secular, the most favorably regarded exemption rooted in some secular reason. We'll talk about how that applies in a practical sense in just a minute. So let's talk, all of those decisions I've just talked about are what are called merits cases. The Supreme Court, what you think of when you think of a Supreme Court decision and you think of people standing in front of the 9 justices, answering their questions, those kinds of things, those are merits cases. They've gone through a process of someone has done what's called a petition for certiorari, essentially asking the court, hey, please take our case. The court has said, yes, we will take your case. And then both sides have done extensive briefing. There have been amicus briefs in the cases and oral arguments. This is usually a process that takes about a year to a year and a half. And then the court has issued a decision. Those are merits cases. There are another set of cases called the shadow docket. And these are, and merits cases, by the way, the cases I was just talking about are precedential. Later cases in trial courts, appellate courts, and the Supreme Court are bound by those decisions. They set legal precedent. They are precedential, not presidential, but precedential. The shadow docket are not precedential cases. The shadow docket is when, let's say, I sue a government official and for a violation of rights, and the violation is ongoing. Let's say I've applied for a petition to have a protest in a month, and because in a month there's some, is symbolic in some way, and we need to have the event on a specific day. Let's say October 17th, and the government denies me that permit, and I believe that they've denied me that permit on an invalid basis and violated my free speech rights. I can sue them for an injunction, asking the court to direct that they allow me to have my event. Now, litigation takes a really long time. And so in that scenario, if you just ask the courts, I'm suing these people, I want you to give me an injunction, it might be 2 years, 5 years before the court decides the case and grants you the injunction you want. But by then, October 17th of this year has come and gone. So I've lost out on the opportunity that I was looking to capitalize on for my protest or rally or whatever. In that situation, what you do is you ask the court for a preliminary injunction. You ask the court to give you your remedy now, because you can show that you are likely to prevail in the end, and having the defendant do what you're asking now wouldn't prejudice or harm them in any way, and the public interest is not strongly against giving you what you're asking for. So I would sue a government official and ask the court for a preliminary injunction, and have them say and ask the court, hey, we're likely to prevail in the end because this is a violation of my free speech rights for these reasons. And it doesn't hurt the government's interest at all for me to have a rally on this particular day. Now, the court can grant you that or deny you that. And if they deny that, then you can appeal that decision, and the appellate court will put things on pause and have their own arguments. And then maybe someone doesn't like what the appellate court says, and so it winds up at the Supreme Court, and the Supreme Court is going to say whether or not, while the case is ongoing, things should remain paused. That's not a case that comes to the Supreme Court in the normal way, and it's an urgent matter. I need to know within a month whether or not I'm going to be able to hold this rally. So there isn't time for, like I said, all of that briefing and holding oral arguments and that kind of thing. So what the court will do is issue a stay or grant an injunction based on usually with what's called a per curiam opinion attached. It doesn't set any precedent, but nonetheless, it impacts the case and gives a signal sometimes as to what the court is thinking about the issues presented in the case. And we saw this again most recently in I apologize for just leaving that screen up there. In the Texas abortion case, the Fifth Circuit essentially paused things at the trial court in Texas. The people who were challenging Texas's new abortion statute appealed it up to the Supreme Court, and the Supreme Court basically said, "Yeah, we're not gonna weigh in on that. The statute's weird and new, and so we're not. It does things that are novel, and so we're not going to weigh in just yet." That is a shadow docket case. It doesn't set precedent for any other cases, but the court has been using it more and more to chip away at religious equality and the separation between religion and government. For example, in a couple of death penalty cases, one involving a Muslim inmate and one involving a Buddhist inmate, the court came to different conclusions as to whether the inmate was allowed to have a faith advisor in the room with them in the execution chamber at the time of their execution. They denied the Muslim inmate, ostensibly on the grounds that it was only 10 days before his execution that he raised this in court. Now, in saying that, the court is ignoring some of the factual history of the case. Nonetheless, that's the fig leaf they used to deny this person the religious counsel they were looking for. On the other hand, 1 month later, they granted a Buddhist inmate the same thing, saying that depriving him of having an advisor in the room violated his free exercise rights. This is the kind of arbitrariness and favoritism that I was referring to earlier with, I mentioned the three words, credulity, inconsistency, and favoritism. These two cases, in my view, should have come out the exact same way, but they didn't. And it's important for us to really sit down and examine why that happened, because the implications of it are very troubling. As it happens, there is another death penalty case in front of the court right now that, it's among my slides down the road, so we'll get to that in a minute when I come to the upcoming cases. So, I talked earlier when discussing Fulton v. City of Philadelphia, the most favored nation theory. And this has been applied in a really troubling way when it comes to COVID. Tandon v. Newsom involved a challenge by a church to California's restrictions on public gatherings during COVID. California allowed gatherings for various activities, going to the store, going to a laundromat, those kinds of things. But it's placed heavy restrictions on gatherings for performances, gatherings of large groups of people for extended periods of time. I don't remember off the top of my head the exact text of California's requirements, but the court essentially said, because you have allowed people to go to the grocery store, you must also allow them to go to church, even though going to the grocery store is a vastly different thing, like qualitatively, religion aside, than going and sitting down in close quarters next to a bunch of other people and chanting, singing, just kind of breathing the same air as them for an extended period of time while there is a respiratory pandemic going on. Nevertheless, the court said that California had to allow them, had to subject gatherings for religious worship to the least restrictive requirements that it placed on anyone, as it placed on anyone else. I hope that made sense. My grammar was a little odd. But this is the most favored nation theory in action and shows how harmful it can be, because there was no consideration given of the burdens that the accommodation placed on anyone else. There was no consideration of, the increased likelihood of a super spreader event, the impact it could have on the healthcare system and therefore on other people, whether getting COVID or needing healthcare for other reasons and being precluded from doing so. We're seeing states across the country, Idaho, Mississippi, a number of others, where hospitals are at or nearly at or beyond capacity, and allowing for no sound reason, allowing people to meet for religious services in this context is incredibly damaging to society at large. When you can meet on a Zoom call and have all the same, benefits. I mean, all the same benefits you can have when you're not sitting next to somebody. I'm not discounting the benefit of human to human interaction. We've all been missing it, but religion should not trump public safety. Nevertheless, the courts have essentially made it so that it does. And although this case is a shadow docket case, and although it is ostensibly not one that sets any precedent, no lower court has to apply the principles laid out in Tandon v. Newsom. The opinions issued by the court in that case essentially guarantee that every court below is going to apply it. And as a result, we'll be much worse off in responding to this pandemic and in maintaining the separation between religion and government and avoiding religious favoritism and maintaining a religious equality. So, yeah. I've already talked about the Texas abortion case. This is Holman, Health v. Jackson, and the court saying that the novel procedural antecedents make it unclear whether they have jurisdiction to hear the case at this time. So I won't go much more into that, especially since we're approaching almost 6:30. So let's talk about upcoming cases. The first one and the big one is Dobbs v. Jackson Women's Health Organization. This is another abortion case. This one was on our radar long before Texas passed its batshit crazy statute. And I want to touch on something, because abortion, strictly speaking, is not an atheist issue. Abortion is a medical procedure, and it affects people who are, able to bear children, and really doesn't have, there's no disfavorable treatment toward atheists or anything like that. But it has become a mechanism for people to impose their religious views on everyone. And I want to mention that because sometimes we get pushback of, you're an atheist organization. Why are you spending time talking about abortion? Because it is people imposing their religious views on others in the guise of regulating healthcare. I had a couple of lengthy discussions with people this weekend about the Bible's test for an unfaithful life. For those of you who are unfamiliar, if you read Numbers 5:11 to 39, I think, the Bible gives instructions. God gives Moses instructions for how to induce an abortion in a woman who may have strayed from her husband, if the husband suspects that she has been unfaithful. It's kind of an insane bit of text. I would, if you feel so inclined, I would encourage you to read it, because it should be used to respond to everyone who promotes the pro-life position on the basis of their religion, at least in my view. Anyway, this case is one that will be argued later this year. We just signed on to an amicus brief filed in the case by FFRF, and essentially would setting aside the Texas case, would overturn Roe versus Wade by the end of this term. So by June of 2022, it may not matter what Texas's statute says, because the state will be allowed to prohibit abortion anyway. So that's one that we're keeping an eye on. It's very troubling that the court even took this case, because the statute in question in Mississippi is almost identical to one that the court declared unconstitutional a few years ago. So there's no reason for them to have taken this case, other than that with the more conservative makeup of the court, they think they can overturn Roe now. So, and I think the Texas case shows that they're probably right. And that is, frankly, a frightening prospect. So, so that's one that's on our radar. The other is Carson v. Makin, which I've mentioned a couple of times. It's one where we'll be filing an amicus brief, and specifically addresses this use versus identity question that I talked about toward the beginning of this event. Maine's constitution requires that they provide free public education to students. And a number of school districts in Maine have a problem because their tax revenue cannot support a public high school. They don't have enough, either they don't have enough tax revenue, or they don't have enough high school students to make building and operating a high school practical. So what they do is they certify private schools that provide a non-sectarian education as essentially public school providers, and children are then attend those private schools. But it specifically said, the Maine's law specifically says that the school, in order to be certified, their program has to be non-sectarian, meaning that it could be a Catholic school, but if the education they're providing is non-sectarian, then they can be certified and receive funding to teach, all the students in a particular district. So it's not a discrimination on religious. Schools are not being excluded from this program based on their religious identity. They are being excluded from this program, to the extent they are excluded, because they have a sectarian education program. And the point of the program is to provide students with an equivalent of a free public secular education. A religious education is not the equivalent of a secular education. Nevertheless, a number of parents have sued to challenge this law, saying that by not certifying sectarian schools, they are depriving their children of their free exercise, because they can't get federal funding to get a religious education. So this case is going to directly raise this use versus identity question. And I'm concerned to see how the court comes out on it. There have the briefing isn't done yet. I'll be filing an amicus brief in late October on this case, and we probably won't have a decision until June of next year. Again, all the high-profile cases tend to come out in May and June. That's when they decide them. So that's another one that we have on our radar for this year. Because if they do away with that line, that use versus identity line, then we may see federal funding going toward essentially worship practice and supporting the exercise of religion directly, which you would think the Establishment Clause would prohibit. But unfortunately, the case or the Supreme Court has been very skeptical of the Establishment Clause, the scope of the Establishment Clause. Lastly, Ramirez v. Collier is the other death penalty case that's coming up. I mentioned those 2 death penalty cases earlier where the question was whether they could have a faith advisor in the room with the prisoner at the time of the execution. This goes one step further. Can the faith advisor be in physical contact with the prisoner during the execution? And from my perspective, whether the faith advisor can touch the prisoner is kind of an irrelevant point. I would argue that the death penalty is unconstitutional, but nevertheless, it's an upcoming case and is a further application of the Muslim wasn't allowed to have a faith advisor in the room, yet maybe the courts are going to say that this I believe Christian individual will be allowed to have a faith advisor in the room, and I don't know, holding his hand or laying on of hands during I don't know what the religious practice involved is, but you can see the disparity there and the inequitable application of the law that's happening at the Supreme Court. We'll see what they say. This one is, again, I believe, a shadow docket case, and so we may, or it's at least an expedited case, so we may know the outcome of it fairly soon. So I mentioned the Establishment Clause a minute ago. The Establishment Clause is not in good shape at the moment. The Establishment Clause is the portion of the First Amendment that the atheist and non-religious community relies on most to challenge government practices that disadvantage our community or that expressly advantage religious communities. It used to be that there was, between the Free Exercise Clause on the one hand, that means the government can't burden religious exercise, and the Establishment Clause on the other, that says the government can't essentially favor any particular religious exercise, that there was some room in between them where states could make discretionary choices between what policies they're going to enact and to what extent free exercise was permitted without violating the Establishment Clause and vice versa. That has kind of gone away. The court has like I said, turned a blind eye toward inconvenient facts in particular cases. I'm thinking particularly of Trinity Lutheran Church and School v. Comer, where they'll just set aside the facts that show that an Establishment Clause violation would result. In fact, in that case, both the state of Missouri and the church that was trying to get funding through the program essentially stipulated, no, the Establishment Clause doesn't matter in this case. And so the court took them at their word, essentially, that the Establishment Clause doesn't apply. Never mind that we're talking about government funding of religious exercise. When the court was well within its rights and should have raised the issue itself. They should have directed the parties to do some briefing about the Establishment Clause implications of the case. They didn't. And when you have both a conservative state and a religious entity agreeing that a particular constitutional provision isn't implicated in their case, and the Supreme Court going along to the detriment of the program itself and the law generally, we should be very careful about giving them too much leeway. So unfortunately, that hasn't happened. and increasingly, the courts are just not paying attention to the Establishment Clause. Also, in American Legion v. American Humanist Association, when the court can say, well, sure, it's a Christian cross, but it's got, secular meanings because veterans. So no Establishment Clause violation. You can see the sort of absurdity that has resulted and will continue to result. The Establishment Clause is not in good shape. The longstanding test for whether or not something violates the Establishment Clause has been the Lemon test, a case arising from a case called Lemon v. Kurtzman. And the Lemon test essentially said that if that a government activity does not violate the Establishment Clause unless it if it has a secular purpose, if it doesn't entwine religion and government to an impermissible degree, and it does not favor or disfavor one religion over another or religion over non-religion. And all too frequently, I mean, the atheist community has relied on the Lemon test in opposing various government practices for decades. And many have failed to recognize that the Lemon test is not really being applied anymore. It's not clear where it applies at this point. It apparently doesn't apply to a 40-foot cross on government property maintained by government funds. So it's not at all clear to me where it would apply. It might perhaps still apply in schools where children have no choice but to be in attendance. It might apply to the funding of religious activities. That's that use versus identity question from earlier. But I'll point out that the Paycheck Protection Program that was instituted by Congress during the pandemic specifically allows for the Small Business Administration to provide funding through banks to religious entities, essentially to pay the salaries of clergy, which I don't know how you get any closer to funding religious exercise than that. And they also gave, because they were religious entities, they essentially said, we're going to give you this money and we're not really going to engage in any oversight. That can't go wrong. So no one challenged that, to my knowledge, on Establishment Clause grounds. And the fact that no one challenged it on Establishment Clause grounds, going back to Michael's question about history and tradition, means that maybe in the future we'll see that. And when someone will see more of this, more funding going directly to religious activity, and when someone does challenge it, they'll say, well, this happened in the Paycheck Protection Program and no one challenged it. So constitutional? I don't know. But I am troubled by the fact that that we're even able to raise that question. And I don't think this court is going to breach a question that we'll find rational or in any sort of sense abiding by what the Constitution actually means. I titled this slide, "Don't Drink the Lemonade," meaning that we should not continue to rely on the Lemon test when arguing that something violates the Establishment Clause. It's perhaps worth mentioning, so if a complaint were to come to me from Atheists of Florida, I wrote a demand letter to a government agency as a result, I would not, the Lemon test, despite it being the prevailing test for Establishment Clause violations for decades, would probably not occupy much, if any, of my letter, because it just doesn't hold any legal weight anymore. And the lawyers representing the government are aware of that. So it certainly can't be the only thing that we rely on. And I don't think that we should be relying on it at all, because if we do rely on it and someone brings a lawsuit, then this court may just say, yeah, the Lemon test is gone, not a thing anymore. We overturn Lemon. So we'll see. I've already touched that case. So in light of the fact that the government is reading the Establishment Clause essentially out of the Constitution in all but the most extreme cases, and that the Lemon test is no longer necessarily valid or applicable, Establishment Clause cases are basically being decided in an ad hoc, just chaotic way which makes it very hard to enforce or for us to bring a claim because we don't know how it's going to come out. And so as a result, we are in our litigation avoiding taking cases where the Establishment Clause is the one basis on which we would bring a claim, because it would be all too easy for the court to decide, well, the Establishment Clause doesn't apply in this particular case, and we're treating this as a case-by-case thing now, so sorry, dismissed. Instead, we're bringing cases that involve multiple rights, whether it's free speech, free exercise in the right context, and equal protection cases. We're bringing a couple of free speech claims at the moment. We have a lawsuit, American Atheists v. Jason Rapert. Rapert is a state senator in Arkansas. If you have heard of him, you have probably heard of him because either of our lawsuit or a lawsuit not against him, but against essentially the state of Arkansas over the 10 Commandments monument that sits on the state capitol grounds. Rapert's organization, the American History and Heritage Foundation, provided, I believe, much of the funding for that 10 Commandments monument, which is why he is involved, though he's not a defendant in the case. We're bringing free speech claims there because he has a practice on his social media of blocking people who criticize him for policies and positions that violate or chip away at the separation between religion and government. And he blocks people, deletes their comments, that kind of thing on his social media account that we believe constitute his official social media accounts, where he is acting as a government official. He has stated that these accounts he uses specifically for the purpose of communicating with his constituents. And that communicating with his constituents he perceives as an integral part of his job as a state senator. Nevertheless, he claims it is not government controlled, that he's only a part-time legislator, and so he should be entitled to block whoever he wants, delete the comments of whoever he wants. And obviously that's censorship and violates the First Amendment free speech rights of those he is blocking, whether they be atheist or Christian or Muslim or what have you. So we're bringing a free speech claim there. Also, our most recent case, Griggs v. Graham, is a challenge to Mississippi's policies and laws around their license plates, where essentially, unless you pay extra for a license plate that is a specialty plate, one that's like supporting the local children's hospital or 4-H or who knows what. Unless you pay extra for one of those plates, the plate you're going to get has "In God We Trust" on it. And the Supreme Court has said, in a case from the 70s, Woolley v. Maynard, that the state cannot penalize you for refusing to display the state's preferred message on your personal property. That case from the 70s involved license plates. A Jehovah's Witness objected to the state's motto, "Live Free or Die," being printed on his plate. So initially he covered "or die" with tape, and he was cited for defacing his license plate. He then took, if I'm remembering correctly, he took a pair of garden shears to his license plate and literally cut the "or die" part out of the metal of the plate. And he was again cited for defacing his plate. I think the penalty was $30. And he challenged those and brought it all the way to the Supreme Court. And the Supreme Court said, the state cannot force you to be a mobile billboard for its preferred message. Obviously, all those same principles apply here, where Mississippi is requiring people to display "In God We Trust" on their vehicles or pay extra. They could also be cited for defacing their plate if they obscure the "In God We Trust" part of the plate. Interestingly, if you have vanity plates, like if you have, "Atheist" as the characters on your license plate, you have no choice but to use the state's standard plate that says "In God We Trust." So the only way to display your own message is to also display the state's preferred religious message. Now, it's not relevant to the free exercise or to the free speech claims we're bringing that the message is religious. All that matters is it's a substantive message that the state is requiring you to send. And so, this is part of our approach where we're trying to think about our issues in ways that implicate other still viable constitutional provisions. Another approach is under the 14th Amendment, the Equal Protection Clause. The 14th Amendment prohibits the government from instituting laws and policies that discriminate between people based on suspect classifications. This is, again, race, religion, national origin, alienage, so whether they are a US citizen or not. Generally, the rule for whether or not something is a suspect classification is whether the community implicated is a marginalized group with a history of being discriminated against. So atheists fit that bill. So that's another provision that we are looking at using to protect the rights of atheists and the non-religious community and members of religious minority groups generally. Because we take the attitude that, a rising tide lifts all boats. So by protecting the rights of atheists, we're protecting the rights of other religious minorities from being imposed upon. And I noticed there are quite a few messages in the chat. I don't know how many are questions. Let me just finish this little portion, because this is sort of a key issue before I get to any of those that are questions. We need to get comfortable as a community with bringing free exercise claims when it makes sense to do so. In the legal context, we're all familiar with atheism is just another religion. And the ridiculousness of that statement. Atheism is in the common definition of religion, not a religion. There's no worship or anything like that. Nonetheless, in the legal context, there is precedent showing that you have to treat an atheist as equivalent to someone who is religious. Their worldview is equivalent. Because it is a set of beliefs that a person holds in the same sort of way as one holds their religious beliefs. Of course, pure atheism, simply the lack of a belief in a God, doesn't require you to do anything. It's whether you're a humanist or a skeptic or that kind of thing that is what would be the set of beliefs that compel you to act. Nonetheless, we have to, in the legal context, be ready to raise free exercise claims when they come up, because there's really increasingly limited opportunities to enforce our rights in any other way. We have brought free exercise claims in a couple of cases, the same two I just mentioned. In Atheist v. Rapert, we raised a free exercise claim on the basis that atheists believe that church and state should be separate and speak out against policies that impose one person's religious views on another. And by blocking specifically atheists for doing that, Rapert has inhibited people's free exercise of their religion in the legal context. The same is true in our license plate case, Griggs v. Graham. Compelling someone to declare on their private property that they trust in a deity is a burden of atheist exercise of their beliefs that there are no deities. And so we bring a free exercise claim in that case as well. Griggs v. Graham is even more salient as a free exercise claim because there's a growing trend, and I haven't really touched on this, but there's a growing trend toward the courts viewing any statement that is critical of a religious perspective or even just an accurate statement of some religious activity as hostility toward that person's religious beliefs. And that because some government official has made a statement that's hostile towards someone's religious beliefs, and hostile there is in some very large air quotes, that therefore whatever policy they're implementing is invalid as a violation of their free exercise rights because it was motivated by their hostility. I've got some news for the courts. Government officials have been hostile toward atheists for their atheism for a very long time. And the history of In God We Trust is replete with denigration of atheists, going back to the Red Scare, and atheists being tantamount to being a Soviet spy. Even the very first appearance of In God We Trust on our currency in the Civil War, or in the wake of the Civil War, was the result of a letter to the U.S. Treasurer by a reverend saying we need to differentiate ourselves from the heathens, differentiate ourselves from ignominious heathenism. And lo and behold, they started putting In God We Trust on all the coins, and then on all the currency. So that is rooted in hostility toward atheists, and you can look at statements going from 1963 all the way up to today, showing that it's intended to be hostile toward the non-religious and is interpreted by the public as hostile toward non-religion or the non-religious. So that makes the free exercise claim there all the more viable in my mind. We'll see how that goes. So there's my contact information. Let me, wow, 50 questions. Let me stop.
There aren't 50 questions. I've gone through and pulled out the questions.
Oh, okay.
His comments. Michael asked, has anyone ever challenged the most favored nations rhetoric simply because the analogy is ridiculous, since most favored nations was originally intended to address the actions of nations, not individuals or religious groups, not to mention the fact that it sets up an us versus them dichotomy that continues the Christian fallacy of the war they are fighting against non-believers.
Yeah, there are, the most favored nation theory has only recently gained traction in the courts, so there hasn't been too much opportunity to push back on it yet. That is something we are eager to push back on. Like I mentioned, it can be applied in ways that are so very harmful. Just look at the pandemic. That it needs to be challenged, it needs to be pushed back against. It's just litigation takes time, and so these things work their way through the courts as over the course of years. So it's going to be a long process.
And I apologize for not having my camera on, but I'm having connection issues.
Sure, I notice I'm leaving my light. If it gets too dark, I may just turn my camera off. I don't have a light convenient to me here, so.
Yes. If I turn it on, the whole thing freezes and I don't get anything. So, Jim, are you going to ask your questions you have in the chat, or are you asking something else?
I'm going to ask the one in the chat.
Okay, then go for it.
I'm going to go for it. Well, first off, I wanted to thank you for your brilliant tour de force of the legal landscape that we're all facing as atheists.
I'm glad it read that way. In my head, it was getting kind of rambling. So if it came off like that, I apologize. But I'll take your compliment. Thank you.
It's a big landscape, and we should have some idea of what's going on. So thank you for that. I did want to ask what your opinion was of the degree of cooperation between the various various forces of good, such as AA, the American Humanist Association, and secularists, and various others, who all maintain legal departments. Are you all working together fairly consistently, or is there some rivalry that may erode the
I'm not going to say there aren't rivalries, but we cooperate pretty closely. I have written amicus briefs with Nick Little over at the Center for Inquiry. We regularly sign on to each other's amicus briefs. We have regular conference calls to discuss legal developments and strategies. And also, each of our institutions has something that they are particularly good at. And so, I make a point, I'll talk about secular celebrants, since I mentioned Nick Little. If someone comes to me saying, I want to officiate my friend's wedding, but the state law says I'm not allowed to, that it has to be a minister of a church or a judge. That's something that, CFI has been working on for a long time. They have their secular celebrants program. So I would refer that case to CFI, because look, the movement has limited resources. We don't require tithes. So we have to use our resources wisely. There's no reason for me or any other attorney in the movement to reinvent the wheel when, if FFRF has written a letter to an agency already, and someone else brings something to me involving that same agency's conduct, I'll let them take point because they've already begun that conversation. Sure, there are friendly institutional rivalries, but no, we all recognize the need to coordinate and oppose a lot of these incursions or breaches in the wall between religion and government in a coordinated and concerted way.
That's encouraging to hear. Thanks.
You're welcome.
Back and forth, I'm muting myself. Does anyone else have any questions? And Michael, I meant to ask you if that answered your question or if you wanted to get more clarification.
No, that's answering my question very well. I mean, I'm just kind of concerned about, this, when it comes to legal stuff, it's not just what you say, but it's also how you say it. And I'm noticing throughout your entire presentation, the Christians are very much framing this as, we're the voice of the nation.
Yeah.
So it's like, I'm just kind of wondering, how do you kind of fight that?
That's something that is not necessarily a fight that can even be fought in the legal realm. That is something that we as a community have to make a concerted effort to change on the ground, be it by putting ourselves out there and being vocal. We have our Atheists Engaged program where we encourage people to talk on social media to their government officials and thank them and encourage them when they are making sound decisions when it comes to the First Amendment, and being critical when they go the other way. Obviously, in a constructive and respectful way. You don't want to be an asshole, but putting ourselves out there, showing government officials that they have atheist constituents, and also showing the other people who are reading those messages, or just other members of the public, if you're out in public, that there are atheists in their communities. We aren't terrible people. We are, their neighbors. We're their teachers, their doctors, even their elected officials. That is a fight that's going to be won interpersonally, not in a courtroom.
Right. How much thought is given into how these arguments are framed? I would almost suggest working with linguists to kind of, like George Lakoff and that, who does a lot of work in that area where, the way conservatives and Democrats frame their different arguments. Because, in many cases, we're using the same metaphors, but the way that they're used is different.
Yeah. That is a fair point. A big part of anytime, I'll speak of our litigation and also one of our recent amicus briefs. We always try to tell a compelling story. The cases that we've brought while I've been litigation counsel, one concerned a neuroatypical boy who was baptized against his parents' will and suffered he had nightmares for years after that, couldn't sleep by himself anymore. He regressed in a number of developmental ways. A student who was bullied for years for sitting through the pledge. These kinds of compelling stories that put the lie to the language and the arguments that the religious are using. We do try and keep that in mind. I mentioned the amicus brief that we filed in New York very recently against in the case involving the Boss Bill and discrimination against employees for their and their dependents' healthcare, reproductive healthcare decisions. We spoke forcefully in our opinion or in our amicus brief that they are attempting to impose their will on both their employees and people who have no relationship with them, their employees' dependents, and that they are essentially, when it comes to, I'll speak of an adult's, a college student, when it comes to that college student's reproductive healthcare decisions, these entities would essentially be holding their parents' job hostage, and now they're asking the court to provide them with the gun. And that is not something that the court can do. And they actually responded in their final brief to the Second Circuit Court of Appeals, essentially said, look, we're unlike what the amici is Latin for friends, which is where amicus brief comes from, friend of the court. But they essentially said, contrary to what the amicus brief and the government would have the court believe, we are not bigots. We're not trying to impose our will on others. All we want is to be able to hire and fire people based on their private decisions. And, I sort of read that and could not help but laugh. I always am glad to see that the other side is forced to respond to our arguments, because it means it struck a nerve, and they felt it was worth responding to. So, we do keep their rhetoric in mind, and we do try and, use our own cases to tell compelling stories, and convey the situation in a way that people will find, that people will be receptive to. I'm going to turn my camera off now since I'm almost completely in darkness.
Okay. Michael, did you have anything else, or?
I think I've asked enough one day.
I have two questions. I wanted to make sure you were satisfied with the answer, or needed to.
No, that was great. I appreciate it. Thanks.
Well, my question, I have two questions for you, unless somebody else has a question. I don't want to intrude on other people, but the Florida license plate says, "In God We Trust." If we cover that and we get fined, can we become part of the same lawsuit, or would it have to be a different lawsuit, or how would we go about doing that?
Interesting. My understanding was that that there was an "In God We Trust" license plate that was among those available, and that you could get an alternative plate without paying extra.
Not that I know of, but I'll check on that.
Interesting. If that is the case, if in order to get a license plate that does not say "In God We Trust," you have to pay more, or you have no choice and you would face a potential criminal or traffic violation or citation or something like that, I think it's absolutely worth exploring.
Okay.
Yeah.
It
would not be the same lawsuit, because ours isn't.
Answer Judy's question.
Okay.
Judy, you have a choice of getting "In God We Trust" on your license or not getting it. If you want other slogans, you have to pay for those. But I don't have it on my license plate.
Really?
Any of them.
Well, thank you, Joe. I did not know that.
But Joe, did you say you have to pay extra for those?
No, I didn't have to pay extra. So if you want a vanity plate, you have to pay extra for that. But if you want "God We Trust," they in fact they hold on here. You want this one or this one? Pick one you like.
Gotcha. Virginia does it that way as well. I mentioned because I live in Arlington, Virginia, and they offer an "In God We Trust" plate, but they offer. I don't have it and didn't have to pay extra for it. I think actually in Virginia, "In God We Trust" is not the default, but a no extra cost option that people can get if they want that.
Oh, that's interesting. We should get that in Florida. Okay, well, that answered that question. I don't think we were ever offered that option, to my knowledge. But
it may. I mean,
yes.
I would not put it past some official at the DMV to say we're just going to give people in God We Trust plates.
Yeah.
And that's a bit of a different issue. That's something that would have to be brought against that one official.
I see.
If they are essentially abusing their position to impose in God We Trust on people. That's not a state policy. That's a policy of that particular official, but is nonetheless worth addressing if that is in fact what's happening.
Yeah, interesting. Well, we get these little stickers every year, so we never go back and get another plate.
Sure.
So anyway, my other question, unless somebody else has a question, I don't want to take time because I know everybody's tired, and I know you must be tired too.
Judy Frank has a question.
Oh, okay. Frank, go ahead. Oops. You're muted, Frank.
Muted, Frank.
Okay, Frank, I unmuted you. What's your question?
Oh, it wasn't a question. I was making a statement. You can get, in Florida, you can get in God We Trust or Sunshine State.
Okay, thank you.
That makes sense.
Yeah. Okay, my other question then is, if we don't use the Establishment Clause, or maybe you're using it in addition to those other items, the free speech and all of that, if we don't use it, are they going to come back and say, well, we didn't challenge on that basis, so it doesn't apply anymore?
It could, and that's part of the issue. Is we have to at least speak out and challenge these policies. But there is a distinction between there is a line drawn between, well, not a line drawn. One can object to something and do so, vocally and, letters to the editor and the newspaper and things like that, without necessarily filing a legal claim. And so it's unclear to me right now if, let's say today, Florida changed their license plate laws so that it was in God We Trust and you had to pay extra to get the Sunshine State one. Whether a bunch of people speaking out about it, but not bringing a legal claim, would 20 years from now mean that a new lawsuit brought to challenge it would fail. And I don't know the answer to that question.
Okay, fair
enough. But nonetheless, I mean, it does mean we have to, if necessary, challenge things in court immediately or as soon as possible, assuming that there are people with standing to challenge a policy and things like that. Yeah.
Okay. Thank you.
You're
any
welcome.
Other questions or comments that people?
Sorry, I couldn't give you a more encouraging answer.
That's okay. Michael, you have another question or comment?
It's not a question, but it's just a comment. Just a comment sort of on the uphill nature of this battle, because, I mentioned before, I work for, one of my jobs is working for the Department of Human Services, and when I do bring these issues to the supervisors, often the people I'm bringing them to have a big giant cross on their wall. They have a sticker on their computer that says, did you remember to ask for Jesus's forgiveness today? And they have a big binder on their desk that's all the Christian organizations that they give out to the employees that they want us to refer people to. So, we really are kind of dealing with people that are very hostile to our message, and I believe that, we're somehow abrogating their rights. It's constantly being turned upon me that, I'm somehow violating their rights by bringing up this non-Christian, even, non-American argument against them. So that's all I just want to say. Someone that's kind of like in the trenches, this is a very uphill battle.
I would be interested to see that binder.
Yeah, well,
that's troubling.
Yeah. Well, it's kind of just troubling in general, just because that many of the organizations. I live in Southern Illinois, which is nothing like you would think the North would be. So, Southern Illinois is more like, Tennessee or Arkansas or, Missouri would be. So it's, I'm very much in almost like a Bible Belt area. So the organizations that do give out help to people do generally tend to be religious-based organizations, just for the simple fact that most people don't trust the organizations that are not religious. They believe that those organizations are somehow trying to convert them to, the evil ways of the world or whatever.
We worldly people are not to be trusted.
Exactly.
I'm sorry to hear that. By the way, if you bring something to a higher up's attention and they and you're ever discriminated against in your employment, I would encourage you to talk to either the Equal Employment Opportunity Commission or I know Illinois has an equivalent agency.
Yeah. I mean, they don't really discriminate against you. They just ignore you and just kind of push you off to the side.
All right. Well, I mean, that's better than discrimination, but not much.
So, the Chicago politics Chicago politics reach all the way down here. It's all the same thing.
Gotcha. Well, I'm sorry to hear that.
Yeah. I was hoping that people up north didn't have to deal with what we deal with.
Oh, we do.
Oh, yeah. There's bits of the South in every state.
I know it is everywhere. But it's sad. All right. Other questions or comments anyone wants to make? So Mr. Blackwell can go and rest and recover because he's done a great job tonight in giving us information.
Thank you. I've been traveling all day, so I am looking forward to some rest.
I'm sure you are. Okay, James Young is giving you a thumbs up. That's a great compliment coming from him. And Frank is giving you a thumbs up, and I can't see anybody else. I have a limited view. So thank you so much. I really appreciate it. I will tell you when the YouTube video is up, and you can make any changes to the comments in it that you want me to make. Just let me know. And thank you.
Sorry, any changes in what was that?
Oh, on my YouTube, I always put comments in there, and I put links to various places in the video itself. So somebody.
Oh, like the video notes. Okay.
Yeah. If you have anything there, because I don't really edit the video. I just kind of take out the front and back end, and everything else stays the same.
Gotcha. Okay.
All right, but I'll let you know when it's available, and also on our podcast.
Well, I appreciate that. Thank you.
And Eileen's giving you a thumbs up too. So we really appreciate it. I've enjoyed it very much. It's been quite informative.
Well, you're all very welcome. I'm always happy to do this. It's fun for me. Keeps me on my toes. I always have to make sure my PowerPoint skills are up to snuff.
Yes, indeed.
Granted, these were a little more text heavy than I like. No getting around that.
No problem. So go and rest and enjoy the rest of your evening.
Thank you all very much. Have a good evening yourself.
Thank you.
Geoffrey, I just wanted to thank you as well. Thank you so much. It was a great presentation.
It was great presentation.
You're very welcome. Thank you all for coming.
Very interesting.
Thanks, everyone. Thanks, Judy, for everything. Bye. Good day.
All right, we will see you next week. We will have Neil Carter from Godless in Dixie. It will be our guest. All right, bye-bye, everybody.
Bye. Have a lovely evening. Bye-bye.
If you are pleased with our programs, please tap the like button and then subscribe to our channel. Don't forget the bell so you don't miss any notices of new material. We usually post new content every week. See our created playlists to discover events thus far this year, or to see a list of topics and speakers from our rapidly growing and diverse collection since 1992.